So we will call the order at 8:07. Mr. Montoni, would you please call the roll?
In keeping with the Eastern time, that would be 9:07. Is that correct?
Correct. 8:07 Central.
Okay, Allstate, California.
Here.
Barbour, Ohio.
Present.
Benner, LNC appointee.
Here.
Bergman, Illinois.
Here.
Bowman, Michigan. Brooksbank, LNC appointee. Brooksbank,
Now see him.
Matt Choco.
Here.
Eiler, LNC appointee.
Good evening, I'm here.
Enzor, PA.
Present.
Johnson, Texas.
Present.
Labrie, Colorado.
This is Alicio. I'm serving as a proxy for Reese.
I'm sorry, what was your name?
Alicio.
That's Alicia Gonzalez. He's actually the Colorado third alternate.
Okay. Leatherman, New York.
Here.
McCose, Alaska.
Here.
Melchin, Nevada.
Here.
I'm sorry, what was that?
He's here.
And I guess I'm here. Seebeck, LNC.
For the moment, hopefully.
Show, Georgia. Thompson, Florida.
Present.
Weir, New Hampshire. Weir, New Hampshire. All right. Let's go through the alternates present. Chatterton, Michigan. Edwards, Georgia. Clift, Alaska. Gonzalez is here. Goodley, Colorado. Carlos, LNC second.
She's likely not going to be here. She has got a serious case of the flu.
Okay, Marinovich, Colorado first. Matz, Illinois.
Present.
Osborne, California. Osborne, California. Redmond, New York. Redmond, New York. Rogers, Virginia second. Rogers. Roaming, PA.
Here.
Veldhuizen, LNC first and Virginia second.
Here.
Okay, if I didn't call your name, you're probably a guest. Mr. Chair, if you could go around the room and ask for, looking at the Zoom
Sure.
screen, ask for the guests to name themselves.
I see Mr. Bowman is entering the room before we go there.
Okay, so he's present.
That he just came in.
Okay.
Let's see, guests, I see, Mr. Chris Cole,
I'm sorry, who is that?
Chris Cole,
Next.
Miss Jessica Tewksbury,
Jessica, that's B-U-R-Y, right? I'll assume that's right. Okay, next.
Mr. Larry Silver,
Next.
Mr. Travis Boast,
Next.
Mr. Rob Latham.
Hello, Rob. All right, if you all would look in the minutes document and make sure I've got you recorded, I would appreciate it.
All right, did we miss
Point of
anybody?
information, how can you have a link to the minutes document?
It's in the chat window. It's like the second message in there.
Mr. Montoni and Miss Harlow's just arrived.
Mr. Chair, I don't see the anything in the chat window about that.
All right, let me repost it then. It is there. Maybe if you came in after I posted it, you won't be able to see it. Hold on 1 second.
I believe that's the case.
Okay, it's in the chat window right now.
Confirm it's there. Alrighty, up on the screen, we have the agenda for tonight's meeting. We've already had the call to order and the roll call, so at this point, we are open for public comment. Members of the public first, if you wish to be heard on something, please raise your hand and we will happily address you. Alrighty, Mr. Latham, go ahead.
Sure. Thank you, Mr. Chairman. Was trying to find the raise hand. So I'm just looking at the agenda for the first time. I see 1.5 is the one I'm kind of following. The title is Parental Relationships. I'd be just interested to know about the choice, if that's going to be the title going forward. I know 2 years ago there was somewhat of a consensus on using family autonomy, and the reason for that would just be that there has been some pushback against the term parental rights, and so the use of something like family autonomy is a little more inclusive. It's recognizing, kind of the interest of both children and their birth parents. So I would just throw that out. In fact, so the group, we used to call ourselves the Parental Defenders Association of Utah, and we're now called the Utah Family Defenders Association, just to recognize that kind of preferred terminology in our field. So that's my comment. Thank you.
Okay, just to address the question, it's only listed as parental relationships in here because that is the current title of the plank, and it's listed that way just for the reference point. If the committee wishes to have an amendment to change the title, they can certainly do so. But right now, it's just for a reference point in the platform.
Okay. May I just add one? I'm looking at the current platform. It says parental rights, not parental relationships. So that's what maybe threw me. I thought this was a
Then
new.
that may be then that is a typographical error on my part, because that's exactly what it should say. I just put it in the agenda wrong.
Okay. Thank you, Mr. Chairman.
Thank you for pointing that out. Now, helps if I actually spell it correct. There we go. Mr. Cole.
Hey, thanks. Just a question on, I was sort of brought into this last week by a couple of, Matt, I guess, who's an alternate in Illinois, and my friend Cash Jackson, who's a libertarian. Some of you may know Cash Jackson, regarding this specific plank, which we also worked on. And unfortunately, we're not able to get to at the last national convention, which we had attended. So we had worked on language. I was given the new language that I guess had been discussed, I guess at a prior time, which I don't disagree with at all. But we did have a plank worked out as well that I was wondering if we could also introduce that language with the group and have that voted on, and then maybe even be able to put them together somehow.
Sorry, I had muted myself. Or were you referring? Yeah. Let me try that again. Yes, I do occasionally tie my tongue into a square knot. Were you referring to the 3.4 free trade and migration plank, Mr. Cole?
No, this was originally, from what it was the 1.6 parental rights plank, but apparently you guys had removed a plank. It's now the 1.5 parental rights plank, the one that's up for discussion first.
No, we had not gotten to that point in the last meeting.
Okay. I don't know where there was I guess a plank, a revised plank introduction that was sent to me, which I read it, and I kind of felt like it had some good language in it. And I also shared that plank that we had worked on with the committee in 2020. And I was wondering if that could also be introduced as we look at revising this plank.
It can. The way to do that, as we're going into debate on the parental rights plank, is to put it up into the chat and ask one of the members of the committee to bring it forward.
Okay.
Just as a reference point, yes, it was 1.6 last year, but the numbering got changed with the removal of the abortion plank, which is why it's now 1.5.
Yeah. Okay.
All right. Do we have any further public comment from the public? Do we have public comment from any of the committee members or alternates? Mr. Bowman.
Yeah, I'll be real brief. Just in looking through what we were going through regarding the entire matter of immigration and trade, I really feel that we should put that at the, if we're going to have it at all, it should just be something at the end of everything else, because having spent, we might say it's, a waste of time if we don't finish it because, we spent so much time on it. Well, I think that's kind of the point. When you only have 90 minutes at a convention and you spend 4 hours trying to hash out language on one plank and we didn't get there, I just feel that would end up then taking up the entire time. That's all.
All right, thank you, Mr. Bowman. I would point out that there is a second proposal regarding free trade and migration farther down in the proposal queue, put forth by Mr. Benner and Van Huysen, which we haven't gotten to yet. There will be a point when we will be taking the work we have done here, and we will go through the process of prioritizing and ordering proposals with the 90-minute period in mind. But we're not there yet. So the best I can say at this point is stay tuned. All right, any further public comment from the committee or alternates? Okay, hearing none, we will move forward into the first carryover on the agenda, which was from 118, excuse me, number 18 from last year, parental rights. Give me a moment, I will bring it up as soon as I can find where the heck it went. Come here, guys. There
Mr.
we
Chair, are
go.
we gonna do minutes for the previous meeting at a different time?
I would suggest to the committee that the committee members review the minutes separate from the meeting and submit any corrections to Mr. Montoni through email.
Thank you, sir.
All right, where are we going here? Proposals, drafts, there we go. One quick moment. We are in the parental rights. As soon as my computer will let it load. I'll do a quick jump between screens. All righty, can everybody see the proposal on screen?
Yes, we can see it.
Yes, yeah.
All right. This was originally part of the proposal 18 from last platform committee. I took a look at it and added some language because there were some pieces that I felt were missing in referring to things such as guardian ad litem, as well as what the roles of families should be in versus the state in raising children and supporting each other. So I've written some language up here to propose that. I will point out here that speaking as both a parent and as someone who has seen what's been going on in the public realm over the past year plus between the various details of what's been going on in the world, that right now, the idea of showing support and backing up the family unit is extremely important more than ever. And we have missed the boat sometimes in this party in regards to that. So we'll keep that. I'm asking that we keep that in mind as we debate this. I will make the motion to bring this to discussion. I will read this as follows. The proposal is to amend the 1.5 parental rights plank with some new language added on both front and back to read as follows. Parental rights 1.5. We support the separation of family and state. We encourage private arbitration and mediation of family issues such as marriage, cohabitation, adoption, custody disputes, divorce, annulment, and spousal, as well as child support. Old language. Parents and other guardians have the right to raise their children according to their own standards and beliefs, provided that the right of children to be free from abuse and neglect are also protected. New language. We reject state ownership or guardianship of children, and we support families choosing to support each other regardless of their composition. Permanent separation of family members must be adjudicated by true due process, not in administrative hearings. I see in the queue Mr. Bowman and then Mr. Johnson. Mr. Bowman.
Okay, first of all, I'm 100% supportive of the proposed language. I'm not going to recommend any changes at all to the language in the body of the proposal. I'm going to express support for the proposal, having been, and I've had personal experience, not direct, well, a friend is the sister of a woman who is now a missing person who's been under state guardianship, and state guardianship is full of abuse. I know we don't have to convince libertarians of anything like that, but as simply a matter of fact, it is. I think the appointed guardian has maybe 1,000 wards. There's no way in heck anybody could look after 1,000 people. I mean, it's ridiculous. Yeah, absolutely. This is right on. One thing though, I just was going to suggest based on conversation I heard in public comments, that I was going to recommend changing the title to familial autonomy. I guess that you could think I don't know if it's in order to move that or not at this time, but if it is, I move that.
That is in order.
Mr. Chair,
Is that Mr. Montoni?
yes, it was. Sorry.
sir.
Can you please post the link to the that document so I can grab the text when we're done with it?
I will put it up in the chat for you right now.
Thank you.
There you go. Alrighty, let's see here. I gotta see who all's in our pipe here. Mr. Johnson, oh, actually, wait a minute, excuse me. We have a motion on the floor. Mr. Bowman, would you restate what you want to change the title to, please?
Again, and I did put it in the chat at one point, familial autonomy, and it's just a matter that grammatically, I think familial, in other words, related to family, is better grammar than family autonomy.
Moment. We're capturing it here, or at least trying to. Okay, so alrighty. The motion at the moment is to change the title of the plank from parental rights to familial autonomy. I will have trouble saying that on the podium, but I'll do the best I can. I currently have Mr. Johnson, Mr. Barber, Mr. Ensor in the queue, but I believe for the main motion. So at this point, I'm going to ask each of them, do you wish to speak on the amendment or still in the queue for the main motion?
I would like to speak on both. However, we want to order that.
Mr. Barber, what say you?
I'm speaking strictly on the main motion.
Okay. Mr. Ensor, same question to you, sir.
I mean, I was actually going to move something similar to this. That's why I had my hand up originally.
Alrighty. I also see Mr. Alstad was in the queue. Mr. Alstad, did you wish to speak on the main motion or the amendment?
Main motion.
Okay, then we will go to Mr. Johnson.
Yeah, I would just simply say, well, I'm sympathetic with the grammar. Nobody's going to know the word familial out in most of the world that we're talking to. I would strongly suggest going with family autonomy. I don't know if the best way to do that is amend the motion or just strike this down. I'll leave that to your guidance, Mr. Chair.
Best suggestion is to vote it down if vote against it.
Okay.
Is there any other debate on the amendment? To change
I don't think you've seen my hand, Mr. Chair.
You're right, I did not. I apologize, Ms. Hollis. Go ahead, but please, I hope you're feeling better.
No, as you can tell, I'm feeling actually 10,000% worse. The last speaker, I agree with. Nobody's gonna know the word familial. They're just not, and I actually don't like autonomy either. I don't think we believe families are completely autonomous. We have a statement in here that they have a right to raise their children according to their standards and beliefs, provided the rights of the children to be free from abuse and neglect are also protected. I think we do much better with sensitive subjects like this, particularly with some of the issues that are going on, and there always are going on around children in the world, to say like family rights or something like that. I think people react a lot more positively to the word rights rather than autonomy. I think when you put in familial autonomy, unfortunately, people are thinking of whoever that guy was, I forgot, who had like, 115-year-old wives and crap out in some compound, Warren Jeffs, like that's the type of thing I think they think of. I think family rights is much better, but anyway, I'd like to be in line for the main motion. Thank you.
I'll put you down on that. Mr. Secretary, just a piece of housekeeping real fast before we continue. Mr. Veldhuizen should be moved up for Mr. Brooksbank, who is not here on LNC, which would move Ms. Harlos into first alternate for LNC as well. And I believe, yeah, that is the only elevation for an alternate we have at the moment. All righty. Any further debate on the amendment?
Hi,
Okay.
this is Chris Cole.
Mr. Cole, we would like to get, you had your hand up to ask to be recognized when we get to the main motion.
It was about the motion as well as the title. I do.
Hold on, sir.
Okay.
Is there an objection by the committee to having Mr. Cole speak? Hearing none, go ahead, sir.
I could sort of agree with Carrie Ann about family rights. The common used language in the shared parenting world that I sort of exist in is parental rights. That's kind of layman's. That's what everybody uses. I feel like sometimes as libertarians we try to be very meticulous with our language, almost to appear more intelligent than others. But I really think that parental rights is fine. Family rights could even be better because that does include the children. Familial, I do know what that word means. Autonomy, these are very technical terms. Yes, we know that the definitions are accurate, but we're trying to speak to the masses, not just to other libertarians. So keep things simple, I would say, is my suggestion. And sort of tightening up as far as the title goes. I guess I won't speak on the amendment itself.
All right, thank you, Mr. Cole. Any further debate on the amendment? All right, since it sounds like there is an objection, we will move to a vote on this. Mr. Secretary, if you would call the roll on the vote whenever you're ready.
Uh-oh. Hang on one second. I gotta finish I need to finish the roll call vote table. Give me 30 to 60 seconds or so.
I'm sorry to interrupt. This is Chris Cole again. Are we I did want to add something to this amendment. I didn't know that we were at the voting point.
We're only voting on the amendment itself, but we have a moment, so without an objection from the committee.
Sure.
Go ahead.
Probably the most important language that I'm not seeing in here, although this is pretty detailed. Having been in the realm myself and fighting for custody and been in out of courtrooms and having a podcast and speaking with attorneys and some of the language that I had put in the chat was language that we were going to use as the plank in 2020. I was wondering if anyone was able to read that and if we could include it. If not the whole thing, I think the most important part that needs to be in our parental rights or family rights plank includes a rebuttable presumption of 50-50. That means that both parents come in with a 50-50 presumption that is rebuttable, pending, obviously if there's abuse or something like that, which would take place in a criminal court with a higher standard with a higher evidentiary standard. Unfortunately, the family courts have a preponderance of evidence, which, as we all know, is just basically the judge's opinion on whether or not he wants you to raise your kids or not. And that's why we have a problem in our family courts, because the judges are given free reign, and there's no oversight. So some of the things that I included in the comment on the right, which was our plank, pretty much tightened up all the issues that we actually deal with in the family court. For any of those of you who have been through it, having recordings in court, ending judicial immunity, meaning a judge can't just take away your kid and, unless you want to spend tens of thousands of dollars disputing it. There need to be protections for that, as well as getting rid of any federal incentives, which would include child support and welfare dollars.
All right, we can look at that in a little more. We'll get back to the main motion. Mr. Alstead, your point of order, the chat normally would be well taken, but in this case, because we were waiting on Mr. Montoni to get the vote sheet organized, we were giving a little bit of leeway there. Mr. Montoni says that he is ready to take the vote, so we will move to the vote. Mr. Gonzalez is asked to repeat the motion, so I will do so. The motion is to amend the title of the plank from parental rights, striking that, and replacing it with familial autonomy. Mr. Montoni, at your pleasure.
Okay. Alstead, California.
Aye.
Barbaro, Ohio.
Nay.
Benner, LNC.
Pass.
Is that an abstain, or do you want us to come back to you?
I would like to be come back to, if that's possible.
Bergman,
No.
Bowman,
Yay.
Choco,
No.
Eiler,
No.
Enzor,
Abstain.
Johnson,
No.
Gonzalez,
No.
Leatherman,
No.
McCose,
No.
Melchin,
No.
I'm going to abstain. Thompson,
No.
Mr. Chair, would you like to vote?
Chair is not voting, but Mr. Benner was passed back to.
I'm going to say no, Mr. Benner.
All right, Mr. Chair, I see 1, 2, 2 ayes. One.
Hey, this is Albert Veldhuizen. I'd also like to record a no vote. I'm substituting for Brooksbank.
Oh, I'm sorry. I accidentally deleted your name out of there. All right, that makes it 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. 12 nay. And 1 abstention, 1 not voting. I'm sorry, 2 abstentions, 1 not voting.
And 2 ayes.
Yes.
Okay, the motion to amend fails. So we are back on the main motion. Bear with me one moment, please, if everybody would. just to adjust things. Alrighty, I had in the queue, I had the following. I had Mr. Johnson, Mr. Barber, Mr. Allstott, and Ms. Harlos. So Mr. Johnson.
I'd like to move to amend and by removing the second sentence.
Hold on one moment. There we go. So you're wishing to remove the sentence, we encourage private arbitration and mediation of family issues, et cetera, and so on?
Yes.
Okay.
And I can speak to that.
I'm just going to highlight it in red for the moment. Not like that, but that's, I wanted to do that actually. There we go. Go ahead, sir.
Yeah, so I have no problem with the language there. The main problem I have is that the plank immediately preceding this one, 1.4, goes into great length already talking about marriage, child custody, adoption, consenting adults, marriage in great length already. This sentence feels out of place in this plank, which was originally focused on children and parental relationships. So I think this plank, that sentence sitting next to the previous plank comes across as very repetitive and could even come across as conflicting in some degrees. I think the proposal is cleaner without it. And if we did want to talk more on those issues, I think it might fit better in the personal relationships plank.
Mr. Alston, sorry, Mr. Johnson, for reference for the committee, could you put the wording of 1.4 in the chat?
Yes, I can.
Thank you.
It is pasted in there.
Thank you, sir. I was asked the committee members to take a look at that in contrast in relation to Mr. Johnson's argument. I'm not saying it's wrong. I just want to see the compare here. All right, fair enough. Okay, so there is an amendment on the floor to strike the second sentence of the proposed amendment. Let's see here now. I've got a pile of people on the list, but I do see that. Okay, Ms. Eiler, you had your hand up before the motion was made. Am I correct? You wish to speak to the main motion?
I would like to wait and see how this plays out
Okay.
before I move forward. Thank you.
All right. Same question for Mr. Cholko.
So
Do you wish to
I
speak
was,
on the amendment or the main motion?
I guess on the main, yeah, definitely on the main motion.
All right. Mr. McCose, same question.
I'd like to speak on this amendment.
Go ahead, sir.
Okay, so I'm looking at personal relationships in front of me. I don't know if anyone else has it here, but it specifically has going into, it talks about sexual orientation, preference, gender, or gender identity on this specific topic. It's not actually talking about this specific topic. It is truly, my view, too specific in personal relationships because it's talking about personal relationships and how they regard into that thing, that the case of custody and all of those things, whereas this is not included elsewhere. I understand if others are trying to say maybe we would amend that plank and include this in that plank, then I would possibly be amendable to that, but otherwise removing said language I would be opposed to from our platform as a whole.
Alrighty, I saw Mr. Bowman, then Mr. Ensor on the amendment.
Yeah,
and you keep missing me, Mr. Chair, just so you know.
Ms. Harris, I had you in the queue for the main motion.
That was before there was an amendment.
All right, I'll add you in the queue for the amendment.
I will speak after Carrie does then, Carrie Ann.
All right, I'll remove you down the queue. Mr. Ensor, did you wish to speak on the amendment?
Yeah, I just wanted to mention that I think this is probably a positive change because it seems a little overly technical. The second sentence does, and cutting it out for simplicity, I think would be a good move.
Ms. Harlows.
I'm sorry, I'm forgetting names. I was gonna, when we were on the main motion anyway, was gonna talk about this sentence. It does seem kind of strange, here, because the whole thing, maybe this is just the tension that we have in our worldview because we happen to live in a state that enforces all of these things. We can encourage private arbitration of and mediation of everything we want. What happens when somebody violates the private arbitration? Then the state gets involved, but we've already said we support the separation of family and state. So what happens when the custody dispute is, resolved by private arbitration and one of the parents still runs off with the kid? Maybe this is just unsolvable, that we just have to state our principles and realize, we're trying to live free in an unfree world. But whoever else had said that this sentence belongs in 1.4, like, the sentence itself is great, but it doesn't belong here, it should be put into 1.4, I think is absolutely right. It's very jarring here, in my opinion. And I do think that personal relationships sentence kind of leaves a hole. And are we saying, we say that actually this might not even, yeah, we say government shouldn't license marriage or anything, but we really don't, we almost, people can walk away from 1.4 thinking that we think people shouldn't get married, but we don't really care whether people get, I mean, some of us do, but I mean, as libertarian philosophy, don't care. So I think having this sentence in 1.4 shows that we understand that people are still going to have kids, they're going to cohabitate, they're going to have custody and all that, and this is how it should be dealt with. And this is going somewhat beyond the amendment, but it's related, so I hope the chair will indulge me.
Go ahead.
Maybe it's just, I know we love saying in every single issue, and God, I almost want to shoot myself in the head for saying this because this sounds so unradical of me. I know we love saying in every issue we support the separation of X and state. But I don't think we actually do completely support, while we have the state, the separation of family and state. If children were literally getting the crap beaten out of them, which is what the third sentence kind of deals with, you don't want the police to come in and get in and protect those children? I don't think we actually do support the complete separation of family and state. I think we need to talk about the specific issues where there's issues like father's rights, custody issues, those sorts of things. But I don't actually think we believe, number one, I don't. If some kid's getting raped by, their mother or father, I want that kid to be protected. And right now, who does that? I don't know. I think those two sentences are maybe, remember, our platform isn't our end goal. Our end goal is the statement of principles. The platform is somewhat interim. And I think we support the separation of X and state in every single plank, and we'd all go rah, 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 and, feel great about ourselves. But I don't think you can say that children have a right to be free from abuse and neglect without implying there's an enforcement mechanism for that. And unless you're advocating, maybe we are vigilantes going around and doing that, we're really not supporting the complete separation of family and state.
Mr. Bowman.
Yeah, I'm just muting myself. Yeah, I've heard some persuasive arguments, but still looking here, there's parts of that first sentence that are very specific to parent-child relationships that are not necessarily compatible or within the same theme as 1.4. The private mediation, okay, of family issues, okay, well, maybe like marriage and cohabitation, but adoption and custody disputes are not really part of that other part regarding personal relationships between consenting persons. And then also the part about child support would not fit into that other plank, in my opinion. So, and the family structure having something to do with child upbringing in this context, I feel it is appropriate to keep this in here. And also just to add my thoughts about some of the comments Ms. Harlow stated. As far as, I mean, violent crimes against anybody, whether it be by a family member or not, be it a victim of any age, I think we already addressed that in terms, and I don't recall exactly how it's worded, but I believe we already have addressed matters of violent crime, and that definitely we're not trying to give shelter to violent criminals, and certainly not people who commit violent crimes against their own children.
Alrighty, I'm going to weigh in on this one for a moment. I will preface this by saying that this is a little bit of a personal issue for me. I was a child of divorce. I was a child who grew up in a toxic, dysfunctional household, and to overcome the details of that, not at the level of abuse or neglect. And as such, I got no support from the state. As a matter of fact, the only good parent I had was turned against us by the state. And as a result, I got a big burr in my saddle over the idea of government involvement in these types of situations, because I've lived firsthand what it means to have it go wrong. And it's taken me a good chunk of a lifetime to get past all of that. And I don't apologize for having that position, because I've lived it. It sucks, but it is what it is. The idea of private arbitration, to me, is at the very least a step in the right direction ahead of government involvement, because as we know, government can screw things up when it comes to these things very, very badly. In Colorado, when I was out there, we had an activist named Suzanne Schell, who was very big upon reform of the state system because of the way that it tried to take away her children from her, to the point where she was even trying to get jury trials for issues of custody, which at the time the LPCO very much supported. The idea here that we're giving a pass to families to abuse their children because we want state and family separated, to me, does not hold water, because that is a last resort. There are cases where families can be abusive towards their children. There's no denying that. But there's also ways to address that without going through the broken system that we have that's called family court, which causes these problems. I would point out that even though it's not totally, it's partially germane to this amendment, that the last sentence talks about due process and not administrative hearings. A lot of these things that happen in family courts are administrative hearings. The stuff that my parents went through in dealing with a divorce and child custody were in an administrative hearing, not in a pure, true family court. There was nobody in that courtroom except my parents, their lawyers, the judge, and myself and my sister. And it was not a full bench trial. It was an administrative hearing. Granted, that was also almost 50 years ago. That's not the point. The point is the system is not designed to handle these types of things in a fair and impartial manner, and it has not been in a long time. And until such time as that system is fixed, and I don't have any confidence it's going to be anytime soon, with all respect to Mr. Cole and Mr. Latham and others who have been, that I know that have been working very carefully within the system to try to reform it, and there's a lot of them, we need to take a stand to say, hey, this is broken. This is a better way. And that better way is outside of that broken system. Now, at this point, I'm going to read through a list here because we have had a lot of hands raised on this, and I want to make sure that everybody on the amendment gets heard. So this is what I have currently in the queue for everything. This is a lengthy list, so please bear with me a moment. For the main motion, I had Mr. Johnson, Mr. Barber, Mr. Aufstad, Ms. Harlos, Ms. Eiler, Mr. Chocol, Mr. Bowman. At the moment, I don't see anybody in the queue for the amendment. Is there anybody who wishes to speak on the amendment from the committee?
I'm off of everything. Remove me from all lists right now, Mr. Seebeck.
Copy that.
Same here, Bowman, Michigan.
Copy that. All righty. Is there any further discussion on the amendment? Hearing none, because there is objection, we will move to a vote. Mr. Montoni, whenever you're ready.
Mr. Chair, was there an objection?
I believe there is, at least, at least there's voiced some, at least by me anyway. So I think this is important enough. We should do a roll call on it.
All right, one moment.
And while he's doing that, I would ask the committee to forgive my little indulgence there, but it is personal.
All right, here we go. Alfstad.
Aye.
Barbour.
Nay.
Benner.
Yes.
Bergman.
Yes.
Bowman.
Nay.
Choco.
Abstain.
Eiler.
Yes.
Enzer.
Yes.
Johnson.
Yes.
Gonzalez.
No.
Leatherman.
Yes.
McCose.
No.
Melchin.
Yes.
I'm going to abstain. Thompson.
Yes.
Vilshuisen.
No.
Mr. Chair.
In this case, I will vote, and I will vote no for the record.
Oops. All right, Mr. Chair, I see 1, 2, 3, 4, 5, 6, 7, 8, 9. I see 9 ayes and 1, 2, 3, 4, 5, 6 nays. One abstention. I'm sorry, 2 abstention.
Okay, that is 17, so the amendment passes and this sentence is stricken from the proposal. Whoops, didn't want to get rid of the period there. All righty. We are back to the main motion. And at this point, Mr. Johnson was up next.
I don't have anything significant more to say. I appreciate what you shared, Mr. Chair, and I would consider a motion in the future to amend 1.4 with that language. I look forward to supporting this language.
Alrighty, Mr. Barber.
Yes, I just have a question on the phrase true due process. I assume when you say that you're talking about in front of a jury.
I'm talking in front of a jury. I'm talking discovery. I'm talking full evidence disclosure, the whole 9 yards, not just he said, she said in front of a judge in an empty courtroom.
Right. Excellent. Yeah, I'm one of those that supports anytime there is an action in a court in front of a judge that there needs to be a jury there. I don't care if it's a parking ticket. So yes, thank you.
Mr. Elstad.
Yeah, thank you. I just want to speak against this motion. I think what we had before is very good. It's succinct. It gives the libertarian position pretty much perfectly. I think adding more words doesn't make it any more powerful. I think everything we want to say was in there to exist. It was in there at the beginning. I have a lot of sympathy for people that have been through the process. I'm sure we've all, along with probably everybody here, either as a parent or as a child, has been through this system and understands how bad it can be. But like I said, I think in this case, brevity is more powerful and we should stick with what we had before. Thanks.
Ms. Eiler.
Thank you. Actually, that timing is perfect. I was pretty happy with the way things are turning out so far, but then based on what Gary said, I would like to add that we're not really dealing with some issues that are very important to parental rights groups in 1.5. Some things like medical kidnapping. So we talk about how children should be free from abuse and neglect, but the government is greatly expanding what they determine to be abuse or neglect and using that as an excuse. So do we need to maybe think about expanding what we consider abuse and neglect to differentiate it from what the state is beginning to say is abuse and neglect? I just wanted to throw that out there. Thank you.
Mr. Cholko.
Yeah, actually, you can put my hand down. I forgot. I don't want to do anything now.
Alrighty. Okay, I have Mr. Bergman, Ms. Harlos, and then Mr. McCose.
Mr. Chair, point of personal privilege.
Yes, sir.
The item that we just voted on, that was the one that began with "we encourage private arbitration, ... Is that correct?
That second sentence was moved to be stricken and it passed. Yes.
Okay, and that is the one that begins "we encourage private arbitration."
Yes, sir.
Okay, thank you.
Mr. Bergman.
Thank you. My question is the word ownership and the need for this word. I'd like to express some sympathy for Mr. Alstad's position, but if anybody has a reason why this word ownership should be in there, and what some of the qualifications might be, let me know. Thank you.
I can answer a little bit of that. The state has taken in various places the position in the past that they view some children as being state property in the idea of not necessarily being a slave, but in the idea of They are protective wards in without any legit parent or guardian, like in the case of an orphan. They have also taken that position when it comes terms of dealing with juvenile delinquents, which may be a whole different discussion. And they have taken the idea that guardianship, a guardian ad litem and similar, have been the idea of ownership of the children. And there have been state institutions, including some public schools, who have claimed, whether it's rhetorical or literal, that they own the children.
Are there actual examples of assertions using the word ownership?
Not that I can rattle off the top of my head, no. But I have heard
That's
them
why I
stated in
question
the
the
past.
use of the word with, and I do have some sympathy, but not, I object to the word.
Is there a motion to strike it?
I move to strike the word ownership.
Okay, I'm presuming we want to take the or out after as well.
Yes, thank you.
Okay, there is a motion to strike the words ownership or. I still have Ms. Harlos and Mr. McCose in the queue on the main motion. Is there anybody who wishes to speak on the amendment?
We should speak on the amendment for sure.
Okay, Ms. Harlos, go ahead.
I do want to speak on the main motion as well, but
Thank you.
But to say just because the state doesn't use the word ownership doesn't mean it isn't what it is. They don't claim that they own all military age boys either, but they do. If they can send you to war to die, they own you. They don't call it ownership, but that's what conscription is. It's an ownership claim. And what the state does to children is an ownership claim. Of course, they're not going to call it that because that sounds terrible. So they find prettier words to call it. Well, I think we should call things what they are. Just like they don't call taxation theft either. Are we going to stop saying taxation is theft because the government doesn't call it theft? No, what the government claims over children is ownership, and we should call it what it is. Thank you.
Is there any further discussion on the amendment?
The words that court orders
Mr. Cole,
use.
Mr. Cole, you haven't been recognized, sir.
Sorry.
Mr. Bergman, your hand is still up. Are you wishing to speak on the amendment or the main motion?
On the amendment.
On the amendment, go ahead, sir.
The word ownership has some implications beyond what Karen Ann's concerns included, including the right to sell something. That's what it's unnecessarily provocative. Thank you.
All right, any further discussion from the committee on the amendment? Without objection from the committee, Mr. Cole? Is there objection from the committee? Hearing none, go ahead, Mr. Cole.
The language that court orders use is the word jurisdiction, which is ownership. Basically, as soon as you file your first motion with a court, if two parents can't agree and you're now of record in a court to modify custody, the court presumes jurisdiction over the matter. And that's the first day that's one parent or the other files a motion for custody, if the two parents can't agree. So they use the word jurisdiction.
All righty, thank you, Mr. Cole. Ms. Harlos, are you wishing to speak again on the motion, on the amendment?
Yeah, actually, in brief rebuttal,
Go ahead.
I think when you're dealing with human beings, I don't think ownership implies the right to sell. I happen to be one of those libertarians who don't believe you can sell yourself into voluntary perpetual slavery, with all due respect to Walter Block. But I do think it entails, when it comes to human beings, the right to control their lives and and direct their destiny. And that is definitely what's going on. I mean, we can't sell conscripted soldiers into perpetual slavery either. But during the early years of this party, when draft was the big thing, if you go back in party history, they called it ownership. That's where this whole phrase of like self-ownership really came from. I mean, obviously there were issues of drugs and prostitution and things like that, but it really came to a head with these young men sitting at home waiting for that dreaded slip in which the government claimed they owned your life. And they couldn't sell you per se, but they certainly owned you. And just me personally, I want to be as provocative as possible when talking about the evil of the state.
Mr. Berg.
A brief response, then maybe control is the better word. Thank you.
All right, I put myself on the list ahead of Mr. Barber here, and I'll get to him in a moment. I was going to say almost the same thing Ms. Harlow said. Who owns you? Not the state. And frankly, we should make that point crystal clear. You know, the state should not own us. The state should not own our children. And whether you call it jurisdiction, whether you call it control, whether you call it custody, whether you call it conscripted, whether you call it slavery, it doesn't matter. It's still ownership. And one of the fundamental principles of this party is self-ownership, because it's from that self-ownership that all of what we stand for in terms of our rights, our liberties, all of those come from that beginning point of self-ownership. And making a clear stand that it is ownership of self and not by others, including the state, I think is essential and important. Mr. Barber.
Yeah, I'm just going to have to agree with what Ms. Harlos and Mr. Seebeck just said. 100%. The exact wording, you know, the government is extremely good at picking words that sound nice but really mean bad things. I'm also glad that Ms. Harlow mentioned the draft. I'm old enough that I just missed the Vietnam draft by about a year and a half, and I remember having a discussion with my father when I was 16 about what that was going to entail, and having had been in the Navy himself, he recommended that if it looks like he told me, if it looks like you're going to get drafted, kid, go sign up for the Air Force. You'll probably, with your eyesight as bad as it is, you'll probably wind up in a nice, safe Air Force base stateside and and working in a electronics repair lab or something along those lines. So anyway, yes, I agree with everything they said, and I believe that this phrase either should stay or I see a lot of people saying change it to control. That's not a bad idea. Obviously, we have to vote down this amendment first. So thanks.
Is there any further debate on the amendment? Hearing none, we know there is objections, so we will move to a vote. Mr. Secretary, whenever you're ready. To restate it, the motion is to strike the words ownership of.
Ownership or.
Excuse me, correct, thank you. Ownership or.
Alsted,
Abstain.
Barber,
Nay.
Benner,
No.
Bergman,
Yes.
Bowman,
Nay.
Choco,
Yes.
oops. Didn't mean to do that. Sorry, everyone. I'm fat fingering everything tonight. Eiler,
No.
Enzer,
No.
Johnson,
No.
Gonzalez,
No.
Leatherman,
No.
McCose,
No.
Melchin.
No.
I'm going to abstain. Thompson,
No.
Veldhuizen,
No.
Mr. Chair.
Not voting.
All right, Mr. Chair, I see two ayes. Twelve nays, two abstentions, and one not voting.
All right, with those numbers, the amendment fails. I had in the queue for the main motion, Ms. Harlos, Mr. McCose, and Mr. Choko, and Mr. Ensign. So, Ms. Harlos.
Thank you. I think that Mr. Latham, I think it was, that brought up a minority report from last term. Here's what's so tough, and I know everyone here is going to have so many different opinions on this, that the plank as it's worded now, the parents and other guardians, blah, 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 free from abuse and are also protected, was very hard fought in 2008. Because it becomes so sticky as to what does abuse and neglect mean. I mean, I could tell you plenty of people who think teaching children standard Christian beliefs is abuse and neglect. And then of course you go to some of the more fringe isn't, I'm not trying to insult anyone with this word, but let's just say the less mainstream religions, such as say a Jehovah's Witness. Do they have the right to deny their children blood transfusions? So it starts getting really sticky. And then if we want to talk about the elephant in the room, do children have a right to go through their natal puberty? I know people have different opinions on that. And maybe this is just unsolvable in a platform. But I just wanted to bring that up there, that I think that's the elephant in the room here. All this other stuff, I think we all just kind of agree on, and we're rearranging deck chairs on the Titanic. When the elephant in the room, as we've seen with battles amongst state parties, is, you know, what do you do when a child tells you they want to permanently sterilize themselves? I mean, is that a right a family has or not? I'm not giving an opinion here. I'm throwing, I definitely have one, but I'm just throwing it out here because, you know, our platform is supposed to deal with current issues up to a point. I mean, not so specific as to have iguana plank, with all due respect to Star Child, but I mean, this other thing I think is a big elephant in the room, and maybe there's better language. Maybe there isn't. Maybe this is the best language. I don't know. It's so hard. Thank you.
Mr. McCose.
I want to echo some of what Ms. Karen just said. When it comes to what we know that this be the state defining what is abuse and neglect. Some of us are in the position that putting your children in government schools is a form of abuse and neglect. Well,
Yeah.
the statists would contend that not putting your children in government schools is abuse and neglect. So I see a lot that this needs to be completely reworked and even considered. That I understand people fought for that, but we have to remind ourselves that who will be defining what is abuse and neglect? Not libertarians when it comes to this. It's going to be the state. And I just I don't really have any suggestions specifically. I do know that we have some audience members that had some language that they would like to see possibly introduced, but the current language does need work. Thank you.
I had Mr. Choco, Mr. Enser, and then Mr. Barber.
So I was, I had several amendments in mind, but frankly, the more I think about it, the less inclined I am to offer any of them. I guess I'm kind of thinking out loud here right now, but I think the best course of action here may be to just vote down anything on this plank and just leave it alone, because it doesn't look like we're really in there's not much agreement on the committee about what the right wording for this thing is. So maybe we shouldn't be putting anything forth. And that's it.
Mr. Enser.
Yeah, so as it was hinted at previously, audience members, specifically Mr. Cole, had some suggestions as to a rewrite, and I was wondering what would be the proper procedure for us to consider that before we go too much further with amendments to this language that we all seem to have some discontent with.
All right, that is a kind of a point of parliamentary procedure. We are currently sitting on the main motion, which means at this point, it would be in order to propose a substitute to the main motion, which could be a rewrite of the plank itself.
Okay.
If we choose to do that, but bear with me a moment. If we choose to do that, the process involved, Ms. Harless will correct me if I get this wrong, because she's the far better expert on this than I am.
I think in the chat she just mentioned that she's leaving because she's too sick to continue.
That's fair. She's been a rough time of it. But my understanding of it is then we would be able to perfect both the main motion and the substitute in parallel to each other, at which point we would arrive at a vote to see whether the substitute would replace the main motion or not. That is one way to handle it. The other way to handle it is to simply keep trying to amend this one as is. However, which way the committee wishes to proceed is up to them, but those are the two routes that are available.
I mean, Mr. Cole doesn't have isn't a rep, but he does seem to be the expert. So I suppose would it be in order for me to move to substitute his language? Because I think he put it in the chat.
That would be in order.
Okay.
Mr. Cole can't move it, but you certainly can.
Okay. I figure I would at least, act on his behalf to bring it up before the committee.
However, I'm going to ask you, sir, to please find it in the chat and restate it in the chat, because there's been a lot of messages that have gone past since then.
Yeah, I was just going to say, if Mr. Cole, if you could repost it, although he would also like to speak on this, which I think is certainly in order.
Let's get the proposed language up first, because you still have the floor for a possible substitute or an amendment here.
Right.
There we go. All right, is that the wording that you are moving, Mr. Barber?
But Mr. Enser.
Excuse me, Mr. Enser. I apologize.
Yep. Yeah.
I'm sorry.
I looked
at the screen and saw Mr. Barber's name with a raised hand. I apologize.
Yeah, I'll move to substitute this.
All righty. I'm going to ask the committee to bear with me for one moment. And I'm going to do it this way. Spelling helps. And then I'm going to take what's here in the chat window, copy that, insert it here. Take that out because that's just flavor. Alrighty, that is in the window. So, one moment for a little bit of housekeeping. Mr. Secretary, Ms. Harlos has left the meeting. So the LNC has lost their second alternate. Alrighty. What I'm going to do here is I need to, well, hang on, not too much. Trying to capture everything in the screen at once and not succeeding very well. Please bear with me for one short moment to capture it all. I think, does that get it? Almost. No, that doesn't help. Let's try.
Scroll up just slightly more. I think you'll get it.
Yeah, let me try that. There we go. Can everybody read that?
Everything is in the window.
Can everybody read it though? Is the other question.
Yes.
Okay, now.
Yeah.
we're in, okay, with the committee's indulgence a moment, we are in a little bit of a different turf for me because I haven't worked in one of these before myself. So I'll ask the committee's indulgence to bear with it. I will explain the process first. Okay, just everybody's crystal clear on this.
I'm sorry, just can I get a point of information? Shouldn't the other version be on the screen too?
It's right above it.
Substitute, we have two open. Oh, thank you.
They're right above it. Yeah, the original is right above the
Sorry.
substitute there on the same screen.
Sorry, I apologize.
That's okay. That's okay. The way we work this is that we have the motion to substitute in front of us. We will go back and forth between perfecting the main motion and perfecting the substitute. We will go one, then the other, instead of all one, then all the other, because otherwise we'll just lose track of everything. I will point out we have 30 minutes left in the meeting, just as a reference. And this is going to be a little tricky to work through it. So,
a point of parliamentary inquiry, Mr. Chair.
Yes, Mr.
So,
Chair.
is it correct that so we don't have to do anything to other than one person saying they would like to move a substitution, and then we just have to work on these two planks? We don't have to vote on this?
The process is that if there is is that the substitute has been moved. So both the substitute and the main original are open for amendment to perfect them in whatever direction the committee sees fit. At which point we have reached a point of no further amendments to perfect them. We will then have a vote to determine if the substitute replaces the main motion.
So that substitute is here, even if nobody except and I'm not suggesting this is the case, but if everybody here, other than the person that moved it, does not want to deal with it, it's still here anyway?
Until such time as the final vote to determine whether the substitute should replace the main motion, yes.
Okay,
which means
thank you.
that nobody has to amend anything. Okay, let's be clear about that. But but the two different parts are open to amendment. I hope that makes sense. All right.
Thank you, yes.
Now, at the moment, before we proceed, I have with hands raised, I have Mr. Barber, Ms. Eiler, and Mr. Johnson. So I'll ask each of you individually, do you wish to speak for, to the main or to the substitute? First, Mr. Barber.
I'm actually speaking to all of the above, but directed at actually Miss Harlow's elephant in the room statement, actually.
Okay, that one I think I'm gonna put you down to speak to that after we get back to the to determining the main motion or the substitute.
Okay.
Okay. Mr. Johnson, I had the same question for you, sir. Which do you wish to speak towards?
To the substitute.
To the substitute. I'm just getting cues lined up here. All righty. We'll start it off this way. Is there anybody who wishes to speak to the main motion first for an amendment to it?
I have a question about the main motion.
Go ahead, Ms. Eiler.
I hope I don't have to make any sort of amendment to remove the S in puts for the substitute. I think it's just a grammatical change that was maybe input incorrectly.
I'm sorry, where are you seeing? Oh,
Yeah, right there.
Federal incentives.
Federal incentives that put profit, I believe would be correct.
Okay, I'm going to treat that as a motion to amend that real quickly. Is there any objection by the committee to fix that? Considering it's only grammatical.
Please no.
Hearing none, we'll do that. We'll just call that good. All righty. Mr. Bowman, do you wish to speak to?
I wanted to bring up the title again. I was going to suggest move to have domestic self-governance as an alternative title for each.
I'm going to take that as out of order for the moment because it is moving to apply the same title to both the main and the substitute, and that would be better suited later once we determine which one we're going with.
Okay.
Alrighty. Mr. Johnson, go ahead, please.
I was going to offer the amendment for puts, so I yield.
Okay. Is there any other debate on either the main or the substitute from the members? Is there an objection from the committee for Mr. Cole to speak? Hearing none, Mr. Cole, go ahead, please.
Thank you, guys. Thank you, Luke, for getting this put up for me. Although I'm not a committee member, I do have a large amount of experience in this realm. I'm a new libertarian because of this exact issue. I work with many organizations as well as have my own podcast on parental rights. And I speak to many experts, including attorneys and judges and psychologists. The main issue I would suggest to this party and this committee is for the Libertarian Party to take a strong stance on parental rights, because it's probably one of the leading issues of all issues that no one is addressing. One of those being fatherlessness. And I can speak from experience. Not all of us dads are walking away from our kids. A lot of us are being pushed out and bankrupted in pursuing our God-given rights or natural rights, whatever you want to refer to. The reason for the language of this substitute plank, which actually Luke was somewhat involved when we drew up this language, as well as a few other libertarians, myself, Cass Jackson, is because we've experienced where the holes are in the judiciary, how they're sort of stealing our children without any cause. The problem with family courts, as I stated earlier, is there is no due process. There's the lowest standard of evidence, which is preponderance. And for those who don't know what that is, that's 51%, which means the judge can just look at your face and decide that mom is going to get the kids and you are going to be relegated as a visitor to your own children, who you were able to see every day before you decided to, break up. I've been doing this for 5 years now. The language below, the language above has some good things. And I'm not saying that we'd have to get rid of any of it, although you don't want a huge plank, I'm sure. The language below that we suggested speaks to all of the issues that allow the courts to abuse us. Specifically, right now, the rebuttable presumption of equal shared parenting is currently the legislation that we are pushing as advocates.
Mr. Cole,
in states. Yes.
Please pardon the interruption. I wanted to ask a question of you about that. Could you explain what rebuttal presumption of equal shared parenting means?
Okay, so the presumption is that we thought that when two parents split up that we have equal rights to those children. However, the way the laws are written up by the courts is, again, the courts get to decide once you file that motion to modify custody. If there's a custody dispute and the parents can't agree, once you enter a courtroom, it is now under the jurisdiction of the court to decide. So especially if you're not married. Now, if you're married, there's a little bit more equal footing. But seeing that we're now seeing that 40% of kids are born out of wedlock, part of it is because marriage laws and people getting, reamed after marriage and divorce. Kids are now being used as pawns in a scheme, in a money profiteering racket, where, well, to get back to your question, I don't want to go on a tangent. So rebuttable just means that there's a presumption when you walk in. If the other party wants to rebut the presumption, they would have to have evidence. They can't come in the court now at a standard of just preponderance, which means they can't just say, well, he hits my kids, or he's a drug addict, or he's not a good father. The judge can't just decide on that. If there's a rebut, the other party would have to actually, the other person would have to be convicted of an actual crime. So it wouldn't take place. The rebut part wouldn't take place in the domestic violence or the domestic courts. That would then go from civil court into a criminal realm where the evidentiary standard is higher, where a judge couldn't just take your kids away because she said so. She said that you're dangerous. There would have to be.
So it's more than a he said, she said?
Correct. But the reason we added rebuttable is because a lot of the domestic violence proponents and advocates said that it's dangerous to just presume that parents are both fit and should have equal custody. So we tried to circumvent their language and add the word rebuttable so that they couldn't dispute our presumption. So what it did was it got the bill passed by putting the word rebuttable. Right now, there are, I believe, 5 or 6 states that have adopted a rebuttable presumption, as well as, and this is since like 2016 or 18, as well as raised the standard from preponderance of evidence in domestic courts to not clear and convincing, but what's the third evidentiary standard? No, I'm sorry, it was clear and convincing. Beyond a reasonable doubt is when you get into like murder and stuff like that. So they raised the evidentiary standard there as well. The rebuttable presumption of equal shared parenting is the most important language that we can include because it's already being used to change state laws. That being said, people like myself could promote the Libertarian Party through this plank. And I could tell you right now that tens of millions of parents would take notice to this party as being the only party that uses this language. As far as, did I answer your question on the rebuttal presumption?
Yes, sir. I do have a second question real fast, and I see Mr. Bowman has got his hand raised. We'll get to you.
Okay.
Ending all immunity, meaning
So
who and what?
So the major issue is judicial immunity. There's also some immunity that attorneys have, which basically allows them to take your kids. And if you want to dispute it, of course, you'd have to go to appeals court. You'd have to spend tens of thousands of dollars more. You know, and we're all not Jay-Z and Beyonce. We don't all have the means to spend $100,000 to purchase our own kids back. So the immunity aspect is basically the accountability protection as far as judges having immunity where they can make decisions. And that actually follows the recording all public hearings. I know someone had mentioned in some states that you're allowed to record your hearings. Maybe you can bring your cell phones in and record the hearing and videotape it. Not in many states. I can tell you right now, we can't bring our cell phones in courts. You have to purchase the audio if you can afford it. And not all courts have operational video cameras, especially in the civil courts. The reason being, it's our belief that they don't want to expose themselves. They don't want the public to realize what's going on in your domestic relations courts, how judges are speaking to parents, how judges are making decisions without evidence, how basically how they're abusing us. So there's a huge aspect on recording, especially in the internet age. If we could all get our hearings recorded by law, where courts could not prohibit cell phones and recording devices, which many of them do in many states, as well as the ending all immunity. So I'm assuming most people here are familiar with judicial immunity.
Pretty sure, yeah.
Okay.
All right. We're running out of time, Mr. Cole, but thank you. I appreciate it.
Yeah.
Hopefully you will be at convention to argue this if this becomes our proposal for the convention. Mr. Bowman, you had your hand up.
Yeah. I would like to move to amend the substitution proposal by adding underneath that paragraph a second paragraph, which would be comprised of the blue text that is at the end of the first proposed change, beginning with "We reject state ownership."
So to be clear, you're talking these two sentences?
Yes.
You wish to amend those to the end of the substitute?
Right, as an additional paragraph.
Okay, there we go. That is in order. Do you wish to speak to that, Mr. Bowman?
Sure. The good points that are made there, I do not see replicated in the substitute. I'm good with the substitute. About the only problem I have with the substitute would be just a practical one of what most people understand some of the terminology that our last speaker addressed. But with his explanation, it sounds beautiful. So that's the only thing I would change, is keep that language that is not addressed.
Alrighty, is there further debate on the amendment to the substitute? With all respect, Mr. Cole, I would like to have the rest of the committee focus on the debate because of our timing. Is there any objection to this amendment to add these two sentences from the primary to the substitute?
Yes.
Alrighty, hearing an objection, we will move that to a vote. Mr. Secretary, whenever you're ready.
I'm not hearing him. Is that just me?
No, I had myself muted. I'm having a hard time keeping up with all this. Alstead?
He had mentioned in the chat that he stepped away for a moment. Maybe come back to him.
Barbara?
Yes.
Benner?
Yes.
Bergman?
No.
Bowman?
Yes.
Choco?
Abstain.
Tyler?
No.
Enzer?
Abstain.
Johnson?
No.
Gonzalez?
No.
Leatherman?
No.
McCose? McCose?
Aye.
Melchin?
Yes.
I'm going to abstain. Thompson?
Yes.
Veldhuizen?
Yes.
Mr. Chair? Mike Seebeck?
Sorry, I was muted. Chair is not voting. Is Mr. Alstead back from where he stepped away?
Mr. Alstead?
I don't think he's back, so.
Okay. The voting is closed. One moment. I see 7 ayes. Five nays. One not present. 2 abstentions and 1 not voting.
I think you would count Mr. Alstead as not voting, sir.
And then that makes 2 not votings.
Okay, 7-5-3-2. Motion passes. Mr. Choco, you had your hand raised, but you also had a question in the chat. Are they the same thing?
Well, no, but can you answer the question first?
I can, and the answer to that is yes. You can speak to either one.
Okay, so in that case, I will speak to the substitute. After the nice explanation we just got, I understand that language significantly better than I did originally. However, we're not looking at including that explanation in the plank. So the second sentence of the substitute language here, I mean, I think is probably not understandable by most people without a bunch of explanation that they're not going to get. I mean, you know, I don't want to repeat all this stuff, but a rebuttable presumption of equal shared parenting, I don't think hardly anybody knows what that means. Ending all immunity, abolishing federal incentives, all that stuff. That's, you know, I sort of get it after that explanation, but I don't think hardly anybody is going to get this, understand what we're saying in this part of this plank. And it doesn't really, it's not really relevant whether those of us on the committee like or understand the language. What matters is that the average reader of our platform understands it, and I just don't think this is even close to meeting that standard. So I would not be able to support the substitute language.
Is there any further debate on either the main or the substitute? Are you sure? I have to ask I'm asking that specifically to make sure. Okay, we have 7 minutes left. We will be moving to a vote on whether the substitute shall become the main motion. So a yes vote would replace the substitute for the main. A no rejects the substitute and keeps the main. Is everybody clear on that?
Can you repeat that?
Alrighty. We are moving to a vote on whether the substitute shall become the main motion. A yes vote would make the substitute the main motion, or replace it. A no vote would reject the substitute and keep the main motion as it currently stands.
Could you, Mr. Chair, could you scroll up a little bit so the text of both is on the screen?
Okay, I'll get the best I can here. Hold on.
There you go. No, I think that's good there.
Everybody see the end of the substitute?
Yes, I have it all if I'm not scrolling on my screen.
Okay, I asked that question because my toolbar is blocking part of it, so I'm not sure what you guys can see. Alrighty. Is everybody clear on how we're voting?
Yep.
Alrighty. So, that being said, Mr. Secretary, when you're ready.
Ofsted, is he back yet?
Yes, he is.
Yeah, I'm back, but I missed too much of the debate. I'm not going to vote.
So you're not voting?
Right. Thank you.
Barbour.
Aye.
Benner.
Yes.
Bergman.
No.
Bowman.
Support.
I'll take that as an aye.
It is.
Coco.
No.
Eiler.
No.
Enzer.
Yes.
Johnson.
Aye.
Gonzalez.
No.
Leatherman.
Yes.
McCose.
Abstain.
Milchin.
No.
I'm going to abstain. Thompson.
Yes.
Veldhuizen.
No.
All right, Mr. Chair, I see. Oh, I'm sorry, I didn't call you, Mr. Seebeck.
Oh man. What are your tallies at the moment?
Hey, that's not fair.
Yeah, it is.
Hold on. 1, 2, 3, 4, 5, 6, 7. I see 7I. 1, 2, 3, 5, 6 nay. 1 not voting so far, and 2 abstentions.
Okay. You may not like me much on this, but I am going to vote no on this.
Uh-oh.
Nay. Okay. That makes it 1, 2, 3,
7.
5, 6, 7. 7. And 2 abstentions and 1 not voting.
So we have 7 each, yays and nays.
Correct.
Okay. The motion to substitute for the main fails because of the tie. We are back on the main motion. We have 2 minutes left. At this point, I'll get to you in a second, Mr. Barber. If there's a motion to extend time to finish this up, that would definitely be in order. Or is there any further debate on the main? Although I think at this point we've kind of beaten that to death. Mr. Barber, go ahead, please.
Okay, sure. Well, you know what? Let's get that out of the way first. I'll move to extend by 5 minutes, and then come back to me for my other comment.
Is there any objection to extending for 5 minutes?
It'd take 5 minutes to take the roll call vote, so that's an objection, and just in general.
Correct.
I can amend that to say 10 minutes then.
That's an order.
Object.
I object as well.
Take it back to 5 minutes and I'll withdraw that objection.
Okay, I'm fine with that too. I just want to extend it a period of time adequate to finish this.
I would strongly encourage the body to support that, just so we can get this plank completed for the night.
So the understanding here is that we're going to move to a vote at this time?
Yes,
Because
sir.
I'm okay.
Okay, I will restate the question. Is there an objection to extending time to complete this plank?
Yes, I object.
There's been an objection by Ms. Eiler. We will be moving to a vote on the motion to extend. Tell you what, let's do this a little bit different. With the body's indulgence, Mr. Barber, I'm going to lower your hand for a moment, but I have you in the queue anyway. I'm going to ask everybody who's in favor of extending to please raise their hands. Okay, last call for that. Alrighty, I see. Hang on. See 1, 2, 3, 4, 5, 6, 7. And I'm just double checking to make sure I'm not counting an alternate by accident. Okay, I see 9 in favor. Okay, let's lower all hands, please. Alrighty, all those opposed, please raise your hand. Alrighty, I see 4 opposed. Hands lowered, please. And abstentions. Not that it means much, but we'll have them raised anyway. I see 1. Okay. Which means I see 3 not voting. Okay, the motion to extend passes 9-4 to 1-3. So let's, at this point, we'll make it quick. We are, and I thank you all for the indulgence on that one, just to try to accelerate the process a little bit. We are at the vote, I believe we're at the vote for the main motion to adopt, but let me double check myself real fast. I believe that is the case. Yes, it is. Okay. So we're at the motion to either adopt into the report or reject the main motion of parental rights. I'll read it off for everybody. Mr. Barber, real quickly. Mr. Barber, real quick, please. You're muted.
Okay, there we go. Sorry about that.
Is this a debate or a point of information?
This is probably more a point of information. You can get back to me after you're done reading it.
Okay. Well, what I'm doing is I'm putting the motion into the body. So if there's a point of information, this is the time to raise it.
Well, okay then. Addressing Miss Harlos's comment, her elephant in the room comment regarding, since this seems to have come up in here and it seems to be a big issue, especially something that Republicans keep raising, regarding especially gender affirmation surgery.
Mr. Barber, you're attempting to engage in debate versus a point of information regarding the procedure.
No, hear me out a second. The youngest person in the world to ever undergo that surgery was a 16-year-old in Germany who did it with the full permission and approval of that person's parents. Outside of that, and probably only a few other handful of similar instances, generally speaking, it's all been people who are legally adults in their particular areas. This is just kind of a misrepresentation, misinformation that has gotten out there. Nobody is going through that without the permission of their parents. If they're underage, it's just not happening.
Point of order.
Mr. Barber, you are not raising a point of order. You're actually debating the question.
That's my point too.
And the point is well taken.
Well, I disagree, but okay. I made my.
All right. The question is stated as follows. Shall the committee adopt in this report The amendments to the 1.5 parental rights plank reading as follows. New language. We support the separation of family and state. Prior language. Parents or other guardians have the right to raise their children according to their own standards and beliefs, provided that the rights of children to be free from abuse and neglect are also protected. Add language. We reject state ownership or guardianship of children, and we support families choosing to support each other regardless of their composition. Permanent separation of family members must be adjudicated by true due process, not in administrative hearings. Mr. Secretary, we will take the roll as soon as you're ready.
Alstead,
No.
Barber,
Yes.
Benner,
Pass, but please come back to me.
Bergman,
No.
Bowman,
Yes.
Choco,
I will abstain.
Eiler,
No.
Enzer,
Abstain.
Johnson,
Yes.
Gonzalez,
No.
Leatherman,
Abstain.
McGoes,
Yes.
Melchin.
Yes.
I'm sorry, was that a yes?
Yes, affirmative.
Okay. I'm going to abstain. Mr. Thompson, I'm sorry, Thompson,
Yes.
Veldhuizen,
Yes.
Seebeck.
Go to Benner first.
Okay, Benner,
I'm gonna say no.
Mr. Seebeck,
Chair is not voting.
all right, Mr. Chair, I see 5 nay. 2, 3, 4, 6, 7 aye. 1, 2, 3, 4 abstain and 1 not voting.
Alrighty, by a 7-5-4-1 vote, the proposal is adopted.
Adjourned.
We will stand at adjournment for this meeting at 10:11. I will stop recording now.